The state is alleging that on February 13th that you did violate an order that was issued Butler County to have no contact with Sean Kerwin Hawker, and they're alleging that you did have contact with Sean Hawker on February 13th, which amounts to violation of a protective order, a Class A person misdemeanor, punishable up to $2,500 in fines and 1 year in the county jail. Okay.
Excuse me, may I speak real quick? I would just like to say that this is kind of harassment. This is like an offensive thing.
I'm supposed to have parenting time. This is ridiculous. Like, the guy just doesn't want to work with me, and he's being punitive.
Okay, Ms. Click, I'm inclined to revoke your bond right this minute.
I don't mean to be disrespectful. I was just trying to bring up that I'm supposed to have these court-ordered rights.
We are on the record in 23 CR 24. Ms. Click, where are you?
I'm so sorry. I'm right here, Judge. Hello.
Okay, you're the one marked superstar. Okay.
Oh my gosh, I didn't change that. I'm sorry. I used this.
All right. That's all right. I've seen other things that are less appropriate. Mr. Andrews, how does your client wish to proceed?
Your Honor, at this time I have reviewed the discovery. I've discussed this matter with my client, and there is referenced in the discovery is another case that is directly relevant to this one. Essentially, this is a criminal trespass, and the evidence that Ms. Click was advised of a no trespassing order is in another case, and that was not provided. So I'm requesting a continuance so I could issue a request for discovery of the other case that would actually have the necessary information to determine, how we want to proceed in this.
Okay. Mr. Regier, your response?
Your Honor, I'm reviewing the affidavit in this matter. There does appear to be reference to some other case. I am looking through my notes, and this would appear to be only the second time that Mr. Andrews has appeared on this case. So professional courtesy to counsel, if nothing else, I do not believe my office would object to a continuance at this point, provided that the court continues the prior bond in this case with all prior conditions, as well as no contact with the victim or address, which is specifically written as a special condition besides all standard conditions in the 500 professional surety bond, which was executed back in May.
Okay.
Excuse me, may I speak real quick? I'm not a lawyer. I don't know how this goes, but I would just like to say that this is kind of harassment. This is like an offensive thing. I was just there on Mother's Day to see my children. I'm supposed to have parenting time. He's not recognizing that. It's just been a real abusive thing. I feel like I have suffered so much, and this is an offensive thing against me, action against me. And I have rights.
Ms. Clark,
I mean, I'm supposed to be able to see my kids. He's been pretty abusive and harassing.
Hold up, Ms. Clark. Who's been abusive and harassing?
Sean Hawker, my kid's father. When I left him, he started.
All right. So Sean Hawker is named as the alleged victim of the trespass.
Yes.
So, okay, and he is what, the father of your children?
Yes, we were together for 13 years. When I left him, I started getting harassing phone calls. When we were passing the kids back and forth, he would scream at me. He's just been very, very hard to deal with. When I try to communicate with him, he would lead things into arguments on purpose and stonewall me, and then I'm gonna screenshot this to show the judge, and like it's just been constant. Okay,
hold up, Ms. Clark, hold up. You made the comment that you're not an attorney and that you don't know how this works. Well, you do have an attorney. a very experienced, competent attorney, Josh Andrews. He's here on the screen with us. And he's asked for a little more time to make sure he has everything he needs for your defense. So I would urge you to take up your concerns, if you haven't already, with Mr. Andrews.
And I will call Ms. Click immediately after this hearing to talk to her some more about that.
Okay, so he can take you down that path. But I think I'm sensing that you're not wanting a long continuance because you say this is harassing to you. So I was prepared to grant the continuance to February, I think, is my next available docket. But Savannah, do you have anything else available on my docket that you can fit it in?
I mean, it's hard to tell with the system down exactly how many cases we have on every day. We can probably put it on the January 29th day. I know that's not a lot sooner than the February, but
I was just thinking, Savannah, we had packed the 29th at some
I know that's why I had moved on to the February one, but
yeah. Well, Miss Click, it just sounds like February is the earliest date. However, if you and your attorney can work out some kind of resolution with the state, maybe we can get that put on Judge Lee's docket, or we can just put it on the trial docket if you can't work it out. So let's go with, what was that date in February?
it's February 12th, Your Honor, at 9 a.m.
Oh, February. I thought it was the 5th. Sorry, Your Honor. But
well, February 5th, if you want it for trial, that'd be the pretrial. Do you want to put it on there?
No, Your Honor, I misunderstood. Okay. I just misheard. February 12th, I'm available.
All right, and if you and counsel work something out where you can make use of a Judge Lee docket, then feel free to ask and see if we can put it on his docket. But for now, Ms. Click, I am going to order that you continue on your bond with all the conditions, including the contact issues with the father of your children. And you'll need to be back here by Zoom February 12th at 9 a.m. unless your counsel tells you otherwise.
I know that this might not be the time to ask, but is there any kind of countermeasures that I can take? Because I'm the one that's being harassed here. I'm the one that's being hurt. I'm the one that's been attacked. I'm the one that's being kept away from my children. He has not suffered any kind of consequence at all. Like, I am not harassing him. I am not hurting him. I'm paying him to hurt me. You know what I'm saying? Like, I'll ask my lawyer. I don't think this is the appropriate time.
All right. I think you've made a wise decision there. So we'll be in recess. Ms. Click is excused.
Several months later.
We're on the record in State of Kansas versus Crystal Dawn Click. Apparently, Crystal Click is not with us. Fill me in on our status, what we're doing today, Mr. Andrews, what our plan is.
Thank you, Your Honor. So on November 6, 2023, I had requested some additional discovery. This is I believe, criminal trespass, if I remember correctly. And the trespass order or notice of the trespass was issued in a separate case. I had requested, I guess, the narrative, officer narrative from that case, confirming that my client was in fact trespassed from the property. I spoke with my client after the hearing on November 6th. I had advised her that I've requested this, additional discovery, that I'm waiting to hear back. Once I get that from the prosecutor's office, I would call her to follow up with it and discuss how we wanted to proceed. I've not yet received that information from the prosecutor's office, and I've not spoken, or I've not attempted to call Ms. Click, and I've not spoken with her since the November 6th hearing because I have not yet received that discovery. So I'm not sure if that is the reason that she's not here today, if it's because she was expecting to hear back from me and has just been waiting to hear back from me.
Mr. Regier, do you know why the information requested in November has not been received by now?
Your Honor, unfortunately, at this time, I am not in a position to advise the court one way or the other. Certainly, I will put a note in the file, but in any event, there is still the matter of the defendant's apparent lack of appearance here today, and my notes do suggest that the defendant did appear at the last hearing back in November. I am showing an appearance bond in the file. Previously, for a date in August, it appears to be professional surety 500 with a second chance bail bond. So I might respectfully defer to this court as to how it wishes to proceed insofar as that issue is concerned.
Okay. Well, Mr. Andrews, let's be again on the record very clear what it is you're seeking from the state at this time.
Your Honor, I am requesting a copy of the narrative or some other type of documentation from the case in which the law enforcement officer trespassed Ms. Click from the property in question.
Okay. So you're saying when he would have removed her or told her she wasn't to be on the particular property in question?
Yes, Your Honor. And according to the affidavit filed in this case, it says, and I quote, affiant checked Butler County case number 2023-00002489. In the documented case, it shows Deputy D. Daninger had previously trespassed Click from the property on February 25, 2023.
All right. Well, I am going to order that the state submit that affidavit or report in Butler County Sheriff's Case 23-00002489 within the next 2 weeks to defense counsel as part of his discovery in this case. And under these circumstances described by defense counsel, you know, I think most people, most responsible people would still think they had to come to court or at least ask their attorney. But I can see where the defendant might think she didn't need to do anything until her counsel called her. So rather than issue a bench warrant, I will grant continuance. If there's nothing further, we'll be in recess on Crystal Click.
1 hour later.
Seems like no matter how I try to organize these so you all don't have to wait, it just never pans out. I always think I've got it organized and I have a plan and I'll get the attorneys in and out or get the jail in and out.
Yeah, such is life, Your Honor. It's busy.
Your Honor,
Ms. Friend?
I'm scheduled on the docket for 9 a.m. Am I still in line?
Hey, you are still on the docket as a
Yes, my name is Crystal Click.
Oh, you're Click, you're not Friends? I think
I'm so sorry.
Miss Click, I called your case and you didn't answer.
I am so sorry. I honestly just woke up and realized that I missed it.
Hold up. I don't have my, Mr. Regier, were you the one on that or was it Mr. Canfield? Who had the Crystal Click case with Josh Andrews?
Your Honor, it was Mr. Regier.
All right, I'm back on the record. State of Kansas versus Crystal Dawn Click. Miss Click has shown up at 10 a.m. She was to be here at 9 a.m. And I believe, Miss Click, you were telling me you just woke up?
Yes, I am so sorry.
All right. This was an unusual situation in that I did grant a continuance. Please call Mr. Andrews and discuss that with him at this time. He will give you the new date and time, but you better not oversleep next time.
Okay.
You're excused.
Absolutely.
Thank you.
Thank you.
4 to 6 weeks later.
We are on the record. State of Kansas versus Crystal Dawn Click. All right, and how does Miss Click wish to proceed? Although I'm not finding her.
Hi. I am so sorry. I actually had to log in on a different device to get it to work this time. I apologize for the wait.
Okay. Well, you're here. Good. Now, you were saying, Mr. Andrews, as far as status?
Your Honor, yes, thank you, Your Honor. We had set this over. I was needing some additional discovery, which was provided by the state. So I have all the discovery on this case. However, in the meantime, a motion to revoke or modify bond was filed by the state, and in it references a narrative report from the Butler County Sheriff's Department, and I don't have a copy of that. So I am asking for a continuance of both the motion and the control setting, just so I could get a copy of that report. In the meantime, I think that it may be possible to work out a resolution on this case with the prosecutor, who again I believe is still Ms. Norris, that maybe would hopefully render the motion moot if we can work something out. So I would be asking for a very, very brief continuance, because I do believe that we would be able to work something out between now and then.
Well, as I look at this motion to revoke or modify that Ms. Norris filed, it's pretty straightforward that on February 14th, 2024, defendant allegedly texted the alleged victim, Sean Hawker. And then, as you mentioned, Mr. Andrews, the Butler County Sheriff's case. So she either did or she didn't. So I think you're right. We can handle this fairly quickly.
I'm supposed to have parenting time. This is ridiculous. Like, the guy just doesn't want to work with me, and he's being punitive.
Okay, Ms. Click, I'm inclined to revoke your bond right this minute.
Excuse me.
Because if you think my orders are ridiculous.
No, ma'am. I was saying the children's father is ridiculous for being punitive and not just working with the mother. I'm just saying,
Right.
I'm
well,
supposed to have
attorney's
these rights.
right. I think you better stop now.
Yes, ma'am.
I assume the children's father is the alleged victim in this case. But if we're talking about court orders here. This isn't any longer just a dispute between you and your children's father. You've gotten yourself one way or another, rightfully so, wrongly so, in the middle of a criminal prosecution. And you have a motion to revoke your bond pending, and I could either go ahead and revoke it right now just based on your comments to the court.
I don't mean to be disrespectful. I was trying to bring up that I'm supposed to have these court-ordered rights.
And now you won't even let me talk in my own responsibility here. So you better let your attorney talk for you. I think he suggested that to you. Okay, well, let's just go ahead and leave this for April 8th at 9. And if any new charges come up between now and then, we'll deal with them as we will. Okay, so anything else, Mr. Regier, on this matter, other than for me to highly emphasize that Ms. Click, no matter how ridiculous she thinks it is, stay away from her children's father, i.e. the defendant alleged in this case?
Your Honor, I believe that adequately addresses the state's concerns at this time in this matter.
Okay. And so, Ms. Click, you're excused at this time, but you don't have any contacts, no texts, no telephone calls, no contact in person. Okay, so you may go at this time, Ms. Click, as long as you honor your bond.
Thank you, Your Honor. Have a nice day.
You too.
Your Honor.
2 weeks later.
We're on the record in state of Kansas versus Crystal Dawn Click. She is here for motion to revoke or modify bond. This is another case getting ready to have a 1-year anniversary. Ms. Click, as I said, you're charged with criminal trespass by remaining in defiance of an order by the owner to leave, dated May 14th, 2023.
Your Honor, I spoke with the prosecutor. I have a proposal that I've submitted to Mr. Canfield, but Ms. Norris, I think, is going to need to review that proposal.
Well, if I set this over, we're going to have to address that bond modification. So it is alleged the state filed the motion to revoke bond. It's file stamped February 29th, 2024, alleging that on Valentine's Day, February 14th, 2024, the defendant repeatedly called or texted the alleged victim, Sean Hawker, as reported to the Butler County Sheriff's Office in case number 24 etc. Wherefore, the state respectfully requests that this court conduct a hearing to determine whether or not the defendant had violated the terms and conditions of her bond. And now the state who filed this motion, Ms. Norris, is not here. And I understand things come up that she may not be able to help it. I don't know. But she's not here, and she hasn't given any instructions, apparently, to her colleagues on how to handle this. So it looks to me like if the state wants to set this motion that they filed back in February over for a while, there's no point in having a motion to revoke bond, is there? Mr. Canfield, you guys still want to pursue this motion to revoke bond if you're not in any big hurry?
Your Honor, I'll move to withdraw the motion for judgment.
Okay. April 22nd, 9 a.m. Ms. Click, you do need to be back here by Zoom. I don't know what was alleged about Valentine's Day, but if you have a no contact order, you mean no contact. Because even though they've set aside this motion today, which I probably would have done even if they hadn't, they can always file another one if you violate your bond. So don't do it if you don't want to go to jail.
Yes, ma'am.
All right. Thank you all. We'll be in recess on Crystal Dawn Click. Miss Click may go.
2 weeks later.
Is Miss Click the one under Grace on the screen?
Yes, Your Honor.
All right. State of Kansas versus Crystal Dawn Click. Counsel, how does your client wish to proceed?
Your Honor, I did receive an email from Ms. Norris, who's the prosecutor on this matter, on Friday afternoon, indicating that she would agree to a plea in 24 CR 139 to the charge of violation of a protective order. And in exchange for the successful entry of that plea, she would dismiss case 23 CR 243 in its entirety. There would be a joint sentencing recommendation of a 12-month controlling sentence with 12 months reporting probation, no contact with the victim, costs and fees to be assessed, all standard conditions of probation, including a mental health evaluation and follow recommendations. My client is willing to accept this offer at this time and would be prepared to enter a plea of no contest to violation of protective order in 24 CR 139.
Yes, and we are also here on 24 CR 149. That is the purpose of the delay. So, Mr. Regier, that is your plea agreement, is that correct?
That is the state's understanding of the proposed plea agreement, Your Honor.
Probation for a year for freaking going and seeing my kids on Mother's Day. Like, oh my God, you guys are so ridiculously looking for something.
Well, then you don't have to go forward, Ms. Click. Do you want to go to trial or talk about this to your attorney some more, if that's the way you feel?
That is definitely the way I feel. I kind of want to go to trial. I'm just not, because I have parenting rights. Okay. It was on Mother's Day. I wouldn't see my kids on Mother's Day, and the guy is just looking for something to hurt me with again. Like, it's just an insult, and I don't deserve to be punished.
All right. Well, I'm trusting you've shared all of this with your attorney, and the two of you came to a conclusion that this plea agreement was in accordance with your will.
Well, I mean, I was told that if I take it to trial, that I'm not going to win.
Well, you know, I don't know the facts. Your attorney's had access to all the reports, but I'm sure he's not going to try to force you to do something. He'll give you his best legal advice, but he's not going to surely.
I mean, this has already been drawn out for a whole year.
Well, didn't you start with another attorney on this case a year ago?
No.
All right. Well, first,
it's already been drawn out for a whole year, and now you want to put me on probation for a year, so I still can't see my kids. Like, it's ridiculous. I think the guy's just running out the clock so he can just up and take the kids away.
Okay.
Like,
Ms. Click, we started out today with just one case on my docket, 23 CR 243. And in that case, you have a long history on it. Going back May 15th to 23, you appeared in front of Judge Hart. There's a lot of notes about that exchange. Mr. Patterson was appointed, but then he had a conflict with the alleged victim. And then at some point, we appointed Mr. Andrews. And
Yeah, I'm getting pretty
then
tired of
he
dealing with
disappeared.
the,
And then I think you may have disappeared. We may
prosecutor.
have had some bond issues. In fact, there was a motion to, we've had some issues on your bond. But now the question is, what are we going to do about this criminal trespass that you were told to? That was in case number 243. I understand that as part of your plea agreement, the state's willing to dismiss that whole case. And
Yeah,
make
but I
that
mean,
go
if I
away.
plead to the other, you want me to do more. You want me to do like a mental
have-
health evaluation, where with the trespass, I
Okay,
wouldn't.
Ms. Click, I haven't asked you to do anything yet on that regard. But in the 24 CR 139 that was asked to be added to this docket and save you a date of coming back for first appearance, I will advise you that in that case, the state is alleging that on February 13th of 2024, that you did violate an order that was issued in case number 23 CR 243 of Butler County to have no contact with Sean Kerwin Hawker, and they're alleging that you did have contact with Sean Hawker on February 13th, 2024, which amounts to violation of a protective order, a Class A person misdemeanor, punishable up to $2,500 in fines and 1 year in the county jail. So that's your new case, and they're saying that if you plead to that, they will dismiss the other case in its entirety. Now, I just need to know if that's what you're going to do or not.
Can I talk to my lawyer again?
Absolutely. Clerk, if you please put them back in another breakout room.
20 minutes later.
Your Honor, my understanding is that after speaking with Ms. Click, she is prepared to enter into the plea agreement that we've previously discussed.
All right.
But now I am not seeing her. Oh, there she is. Okay, yes.
In and out again.
No,
All right.
no, she's back, Your Honor.
We're back on the record in 2023 CR 243, which was scheduled for control today with Attorney Andrews for the defendant. We are also here on what appears to be a requested first appearance in 24 CR 139. I have gone over the charges, as I recall, with Ms. Click, and we were going over the plea agreement, and she wasn't totally happy about that. I will, for the record, clerk, appoint Mr. Andrews on the 24 case as well. And now, Ms. Click, picking up where we left off, when you were telling me your feelings about the charges and the plea agreement, after you've had more time to talk to counsel, do you still want to go through with the plea agreement or not?
Yeah, I guess that's really my only option.
Okay, well, I can't have you doing this kind of, it's my only option thing. You have several options. You know what they are. Is it the one you choose freely and voluntarily?
Yes.
Is anyone making you enter this plea agreement today?
No.
All right, you're not being forced or threatened to do it.
No.
All right. And have you had enough time to talk to your attorney about it?
Yes.
All right. And you're pleading, is it no contest in the
2024 CR 139, Your Honor.
That's one she's pleading no contest, is the newer one, the 24?
Yes, Your Honor.
All right. So just to remind you, that's the one where the state's alleging that on February 13th, 2024, you violated a protection order that had been issued in another case and had contact with the person you were ordered not to. Is that what you're pleading no contest to?
It's my only option, yes.
Is there anything more you want to say about that being your only option?
Yes, I mean, I was under the impression that my attorney could actually go back to the prosecutor and say, she doesn't want to plead to this. Can we do this? Like a counter offer type of thing. Is that not a thing?
Well, they usually do that. They can either do it in several discussions or one discussion. All right, I'm not getting the impression, Ms. Click, on either of these cases that you feel you are freely and voluntarily accepting the plea agreement where they dismiss the one case in exchange for plea to the other and recommend probation. Am I correct that you don't want to accept that offer?
Yes, that's correct.
All right, so you want to set this for jury trial. You say that's your only option. You have an option for a bench trial. You have an option for a jury trial. It may not be what your attorney thinks is best for you, but if you want to do it, I'm sure he won't stand in your way.
I just wanted to make an offer for something less than a year probation, obviously, because I've already spent a year on this and like it's kept me from seeing my children. I'm actually worried about what this guy's trying to do.
All right, so I'm going to set this for jury. Do you want bench trial or jury trial? Do you want a jury of 6 coming in and deciding your fate on these two cases, or do you want the court to hear the evidence and decide?
I'll just take the plea.
So do you understand you do have more options than just taking the plea?
Yes, ma'am.
And that's what you want to do. Is it not because anybody's making you, but because that's what you want to do?
Yes.
All right. So the violation protection order in 24 CR 139, you're pleading no contest. Is that correct?
Yes.
You're not admitting the charge, but you're not denying it either. You just are going to stand mute knowing you'll be found guilty. Is that all correct?
Yes.
All right. And you understand that if I finish this plea agreement with you, there will be no trial in either case. One will be dismissed and will proceed to sentencing in the other.
Yes.
And do you understand that as a judge, I am not a party to your plea agreement and I am not held responsible for following it? Although I often do, I don't have to. Do you understand that?
Yes.
Okay. So for a factual basis to support this no contest plea, Mr. Regier?
Your Honor, pursuant to the affidavit in the 2024 case, that paragraph 4 would appear to refer to an address in El Dorado, Butler County, Kansas. Paragraph 5 goes on to a series of text messages, which pursuant to paragraph 4 appear to have been provided by the victim to law enforcement. And those text messages would appear to have been sent by the defendant to the victim. And pursuant to the paragraph 9 of the affidavit in the 2024 case, it would appear to refer to the other case currently before the court, 23 CR 243, as part of a bond release condition.
Well, and I understood the defendant tell me earlier in these proceedings today that she made arrangements to see her children for Mother's Day, but this allegedly happened February 13th of 24, Mr. Regier, which isn't close to Mother's Day.
Your Honor, the criminal trespass was the Mother's Day incident.
Okay, very well. All right. I accept the no contest plea and find this factual basis exists. I find the defendant guilty of violation of a protection order in 2024 CR 139, and I dismiss with prejudice for plea agreement the case in its entirety, 23 CR 243. So, Miss Click, you're not even being convicted or sentenced on that case that you thought was ridiculous. So your attorney helped you get that dismissed. But we do have to proceed to sentencing for violating a protection order in February of this year, 2024. So recommendations, Mr. Regier?
Your Honor, the state's understanding of the plea offer, as previously reiterated by Counsel Andrews, is a 12-month underlying sentence with 12 months of reporting probation with court services, no contact with the victim, costs and fees with all standard probation conditions, mental health evaluation following the recommendations. The state is still of the opinion that those are appropriate in this matter.
All right, Mr. Andrews, anything further before sentencing is pronounced?
Your Honor, I would join in the recommendations of the state pursuant to that plea agreement, a 12-month controlling jail sentence, but with 12 months of probation with court services, costs and fees, standard conditions of probation, including no contact with the victim, Sean Hawker, and mental health evaluation and follow any recommendations.
All right, Ms. Click, tell me, you're a mother of how many children?
Two boys.
2 boys, and they live with you or with Mr. Hawker? Or?
They live with Mr. Hawker.
Okay. And do you work? Do you have a job?
Yes, ma'am. No, I'm sorry. I was just going to CDL classes. It's a month-long, 10-hour-a-day thing, and I haven't found a job yet. No.
All right. So you're looking at over-the-road trucking or some kind of commercial driver's license?
I'm not really sure. I'm not really sure where I am with that.
But you're not employed. How long have you been unemployed?
A couple of months.
What kind of work did you do before?
I was driving a cab.
Okay. Well, at this time, I'm not going to assess a fine, but you will have $158 in court costs, $60 supervision fee. I will waive the attorney fees at this point. Your controlling sentence will be for 12 months, but I will follow the plea agreement and order that you be given 12 months of supervised probation to be supervised by the court service office. You will need to call them immediately after this hearing. Do you have your pen or pencil ready?
Yes, ma'am.
No one should ever come to court without that. All right, Ms. Click, as soon as this hearing is over, report to probation by telephone at 316-322 4153. Right? Did you get that?
Yes, ma'am. Yes, ma'am.
Okay.
Yes, Your Honor.
All standard conditions of probation will apply, plus special conditions that you set up a mental health evaluation. I want you to call and get an appointment for that. That call needs to be made within 14 days of today, or as soon as they can get you in for the evaluation. You are ordered to comply with all recommendations in that evaluation, which means if they don't think you need any treatment, you don't have to get it. But if they want to see you every day, they can see you every day, whatever you need to do. And then there's a special condition that you have no contact with Sean Hawker. Don't know about him, his place of business, his residence.
I don't do those things. He's a piece. Okay.
Excuse me?
I'm so sorry. I said I'm not going to do those things. Let me put myself on mute. I apologize.
No, unmute. You're in an open court and I want to talk to you. Now, if you're not going to do those things, I'm not going to follow the plea agreement and grant you probation.
No, I'm saying I'm not going to go and see him. I am going to follow that. I'm so sorry.
You had me worried that I was going to have to make you go down and start serving a 12-month sentence because probation is a privilege that we want you to be successful with. Fines and costs, you're going to have to pay a total of, it looks like about $218. I'm thinking of giving you, can you get those paid in 60 days? Or do you need a little more time?
I need way more time.
How much more time?
Oh, gosh, I don't even know.
How much per month can you pay, do you think?
God, like $30?
Well, I'll tell you what, I'll start you out at $30 a month, but as soon as you get your job, you need to let court services know, and we need to increase that. Otherwise, you may be on probation for a long, long time. So your first payment of $30 will be due May 22nd, 2024. And then you'll have a $30 payment every month thereafter. Now, if probation decides they want to increase that, they can either work that out with you and take care of it that way, or we can come back to court if we need to. But I'm going to start you out at $30 a month. Don't miss a single payment. Because if you violate your probation, you can end up serving that 12 months in jail. Anything else, Mr. Regier, that we need to address?
Your Honor, for purposes of preparing the journal entry, do I have leave, if it is the order of the court, do I have leave of the court to journalize that the mental health evaluation shall be scheduled within 14 days of today's date?
I would ask that you please do that. Put that in the journal entry.
Nothing further from the state, Your Honor.
All right, Mr. Andrews, anything further from the defense? You're muted, Mr. Andrews. Was that a nothing further?
I apologize, Your Honor. Nothing further, Your Honor.
All right, Ms. Click, anything further before I let you go to call your probation?
No.
All right, you're welcome. Now be successful and you won't have to come back to court again, okay? All right, Savannah, was there anything else?
Just the warrant on 2024 CR 139. Did you want that withdrawn?
Yes, if we have an active warrant, there you go. You just got a warrant lifted on that too.
And forgive me, Your Honor. My understanding is that this is the first time the 24 CR cases come before the court. I'm not sure if the court is going to make any orders concerning booking at this time.
You do need, since you weren't picked up on that warrant, you do need to go out to the county jail and get your picture and prints taken. Deputy, do you have any advice on that?
What was the charge on the 24?
I'm so sorry. I cannot make it to Butler County Jail. I can't make it to Butler County. I don't have it. I can't.
Ms. Click, you're kind of starting to try my patience by telling me what you can't do and won't do.
I just don't have the transportation. I don't have the money.
Hold on a minute. Just hold on a minute. All right. The charge, deputy, is violation of a protection order.
It occurred.
It occurred February 13th of 2024.
Okay, that's all we need. We can put her in a breakout room and we'll schedule her a time.
All right. You're done, Ms. Click. You're really making it a lot easier. You've got so many problems with probation. It'd be a lot easier just to put you in jail for 12 months. Please, if you don't want to do that, work with us, or you're going to be right back in here and you're going to end up serving the 12 months because you're not doing what you're told. So you're going to go into a breakout room with this court security, and they're going to figure out when you're going to get over there and get that done. But that's an order of your probation that you get that done.
Can't get it done. I can't. I don't have the fucking transportation, dude.
All right. We don't use that language in court. That's contemptuous behavior. Well, where are you right now, Ms. Click?
I'm at home. I don't have a car. I don't have 80. Actually, it's more than $80 to get there by Uber. I had to do it before because of this person. Like, I just can't get there.
Stop, please. What town do you live in?
I live in Wichita.
Who transports you around town?
I take the public the bus. I take the bus.
Well, you're really making me think that probation is not workable. Maybe I just need to send an officer over to get you and bring you to jail and have you start your 12 months. That I know,
my children on Mother's Day.
Make you do. That I know I can make you do. So if I don't do that right now, can you maybe talk to the officer in the breakout room and figure out when you can get over here?
I just can't do it. I'm not going to be able to do it.
Your Honor, would it be possible for me to have a breakout room with Ms. Click to talk to her about what her options are?
Well, our options are pretty simple. You do it or you're in violation of probation. We do a warrant again. Yeah, you can have a breakout room with her, Mr. Andrews, but Ms. Click, we need to get this moving.
Thank you, Your Honor.
Click again.
20 minutes later.
Your Honor, my client, Ms. Glick, is ready to have a breakout room with the court security to arrange for how she can get over and get booked and processed as the court had ordered.
All right, thank you, Mr. Andrews. Savannah, if you could please put Ms. Click and court security in a breakout room. And Ms. Click is excused from this portion of the proceedings. Mr. Andrews, have you have anyone else on the docket?
I do, Your Honor.